sun.
Let's listen to Pavarotti.
The only one.
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And, I'm kind of excited for this video, and it's interesting. I've been listening to some other creators out there because I have to do that to make sure that I'm up on everything in the case as I investigate other aspects. And it's interesting. A lot of people have a lot of very good opinions. Sometimes those opinions kind of lean towards me and what I'm saying, and that's perfectly fine. I was watching one here recently that was bringing up some very good points. Now, it seems like, and maybe I'm taking it the wrong way, but it seems like the more that people try to discredit the work that I've done, the less they're able to do it through actually discrediting the work that I've done. The things that I'm putting out there are a little bit too much for most people to try to overcome. So they take a different tactic, very subtle one. They try to downplay the importance of what I'm doing by saying, well, if they're right and all of this is true, it will never make it into court. So it's a waste of time and effort because they cannot actually bring in an alternative suspect defense in the trial. And the judge will never hear it and the jury will never hear it. Well, that is a way to make my work not meaningful. However, I love it. For me, it's always a challenge. And, it's kind of good that they brought it up because it's something that I've been thinking about for a long time. And I hear it in my comments a lot too. How will this ever make it into trial, Pavarotti? And I have been studying on that now for months. And I think this is the perfect opportunity for me to show you how this is all going to make it into trial. The alternative suspect defense, which is not an easy one to bring, especially in Idaho, because there are rules that you have to follow. And the more you learn about the court system and the rules and the things that you can do and that you can't do and things that you don't even know if you can do or can't do, it makes our court system so convoluted that it needs to be reformed, because I assure you what we have today is not what the founding fathers had in mind when they set forth our judicial system. You cannot even, there's no, Congress can pass laws all day long. You never even know what the laws are, because even the attorneys don't know what the laws are. And really the judges in most cases don't know what the laws are, because it's all based on precedent and argument. And there's precedents for and precedents against. So there's really trying to figure out just what's legal and what's not, and what's permissible and what's not it's rather impossible. I mean, it's pretty much just, if they want something to work a certain way, then one attorney argues for it, the other one argues against it, and the judge ultimately rules. So, I mean, if they're going to do it that way, why don't they just make it where, okay, there's no such thing as precedent or anything. Just you make an argument, and the guy will rule, and then there is no law of the land. It's just whatever that guy rules is the law, because that seems like what we've got now. It's really close. Versus, okay, this is against the law. Okay, this is what you have to do, and then everybody's clear on things. But no, when you really dive into, especially a case like this, and you start looking at all those things that, anyway, I'm on a side rant here, but some things are clear, some things are relevant. And what I'm going to do in this video is I'm going to show you the deep dive that I've done as it relates to the alternative suspect defense that the Bryan Kohberger team will absolutely put on at trial, how they're going to do it. And you can bet almost everything that I've put together in my series is relevant in this case and can be brought up at trial in an alternative defense. And I'm going to show you why it can be brought up, how it can be brought up, and how it most likely will be brought up, and the relevance to it, and the reason that it should be done that way. Yes, I have deep dived. So, I'm excited to go through and show you what I found. And it's almost so exciting that I'm like, man, I can't wait till this trial. This is going to be, this trial is going to be freaking amazing. However, I can't really get like that because I know that they got the wrong guy on trial. So I've got to hope for a dismissal between now and then so that, a travesty of justice is not even carried out. But if it doesn't, if this thing goes to trial, let me tell you, this is going to be the trial of the century, folks. Wait till you see what I got to show you in this one. It's pretty cool. Also, I'm snowed in. There's like, dang near, there's 2 feet of snow out here. I can't do anything. I live in the mountains, folks. When it snows like this, I've got a big 4-wheel drive, but getting stranded on the side of the road, even with a 4-wheel drive, isn't a fun thing to do in the mountains, I assure you. So I can't go to the gym. I can't do anything but focus on this case. So today I'm going to spend it investigating, preparing my video for tomorrow night, because the video tomorrow night is going to be a barn burner. I'm taking the information that you gave me in our surveys for the roommates, and I'm putting together the most plausible scenario that I can possibly put together for the atrocity on King Road. You don't want to miss that one, and I hope to have it out to you tomorrow night, probably around 7 o'clock. Today, I'm also going to be putting out a video on the new court docs that just hit. Yeah, we've got some big time court docs that just hit. We've got the state's objection to the defendant's motion to compel the 16B7, all the sanctions. State filed an 11-page objection, just hit the court docs. We can see it. The defense has already filed their reply. Just hit the court docs. We can see it. We also get to read a good portion of that subpoena that the defense just submitted. So there's some big docs. I don't just pull them up and read them. Y'all know that. I got to go through and study them so that when I pull them up, I can talk to you, with a little bit of grasp of what we're actually looking at. So I'm going to be working on that today, and I will get that video out to you later on today. But right now, we're going to get into this alternative defense of the alternative suspect defense that we will see in the Bryan Kohberger case if it goes to trial. I assure you, let me show you what I've got. Now, I just mentioned this is a very tricky thing for the defense to do, is bring up an alternative suspect defense in Idaho. So let's get a little clarification on it first. To introduce an alternative suspect defense at trial in Idaho, a defendant would need to utilize Idaho Criminal Rule 16, discovery and inspection, to disclose the existence of the alternative suspect during discovery, then present evidence at trial demonstrating a plausible connection between the alternative suspect and the crime, aiming to raise reasonable doubt about the defendant's guilt by highlighting inconsistencies or evidence pointing towards the other individual. However, it's crucial to ensure the evidence is relevant and not overly speculative as per the general principles of evidence law. And then we get into the discovery obligations related to that. The defense must disclose the identity of the alternative suspect to the prosecution through discovery under ICR 16, allowing the state to prepare to address the argument. And then reasonable doubt. The goal of presenting an alternative suspect defense is to create reasonable doubt about the defendant's guilt by showing that another individual could have committed the crime. So if you're going with a straight alternative suspect defense, and you have an actual alternative suspect, then you would need to disclose that to the prosecution. Now, we don't know if the defense has an actual alternative suspect. They may just have an alternative suspect scenario. So there's two ways they can attack it. If they do have alternative suspects at this point, which they may very well have, then they would disclose it to the prosecution in the discovery process, and then they would bring it up during the trial. That seems to be a way that the judge could overrule it and keep it out of the trial altogether. So I think another way for them to do it is more likely and will probably be the way that they do it. But why would you want to do it? Again, the goal of presenting an alternative suspect defense is to create reasonable doubt about the defendant's guilt by showing that another individual could have committed the crime. And studies have shown that that is the most effective way to get an acquittal. And let me show you. Okay, here's a study that was conducted by the University of Virginia, and it was designed to see what are the better outcomes for a defendant, one that does not present an alternative suspect defense, and compare that to ones that do. And it says, how does a criminal defense attorney argue for a not guilty verdict? One strategy is simply to argue that the state's case is incomplete and has not been proven beyond a reasonable doubt. That's what a lot of people suggest the Kohberger defense team to do. I disagree. No more is required. Another strategy is to provide alternative explanations of each piece of evidence. For example, how the defendant's blood got in the victim's car or that other people had keys to the home. A more specific version of this strategy would be to provide a complete alternative story, implicating unnamed or named others that explains all of the evidence. Thus, the defense may choose to enumerate some of the possible explanations for individual pieces of evidence or for the crime as a whole. The toddy, that this other dude did it, is a slang term for the defense strategy in which attorneys point to a specific other possible perpetrator who could have committed the crime. Our laboratory studies suggest that a defense strategy that argues not only that the defendant is innocent, but also that some other individual or individuals could have committed the crime is more likely to result in acquittal. So there's no question about it. If you go into it with a simple strategy that the state did not prove its case through evidence and you don't provide any kind of alternate defense, then the chances of acquittal are much lower than if you're able to explain away the evidence in an alternative defense strategy and also name that other individual or individuals could have committed the crime. You're much more likely for it to result in an acquittal. And that's what we're going to see in the Kohberger case, I assure you, and I'm not the only one that believes that. You see, this guy right here is very interesting to me because even though he has written a book that explicitly states Kohberger is guilty, he actually dedicated 2 chapters in his book to the defense's strategy, possible strategy in the case. And he's also given interviews stating that. And when I watch all the interviews that he does, I guarantee you, he wants to be able to talk about the possible innocence of Kohberger, but that isn't what anybody wants him to say. So anytime he starts to do it, he gets shut down and he shuts himself down and goes in another direction. But there is no doubt with all of the interviews that I've watched of him and after reading his book, he is probably the only one out there that has offered any kind of alternative anything for the defense in mainstream media. Everybody else is 1,000% not touching anything that doesn't prove Kohberger's guilty. He's the only one that kind of tries to bring it up. But when you talk about relevance and admissibility, the evidence presented regarding the alternative suspect must be legally relevant and admissible, meaning it must have a logical connection to the crime, but not be unduly prejudicial. And in his book, he clearly outlines what the defense's strategy will be, and he tries to do it in interviews as well before he's shut down.
I know the defense has spent a lot of time trying to build up the drug case.
Now, let's think about that statement he just made for just a minute, right? Because in the early days, Howard Bloom spent a lot of time in Idaho doing his research for his book that turned out to not be a good book. Last 2 chapters, pretty good though. But he did spend time with the defense team's investigators. So he's very accurate on what they spent their time building up. But think about it for a second. When he says they've spent a lot of time building up the drug case, what does that mean? Have you heard anywhere out there in mainstream media about the drug case? I'm pretty much the only one that talks about it on social media. So what do they mean what does he mean when he says they've spent a lot of time building up the drug case? They're not building it up for the media, for the public. They're building it up for the defense, folks. That's the only thing that they could be building for, is the defense of Bryan Kohberger. So when he says they're building up the drug case for the defense of Bryan Kohberger, they're not doing that just so that they know it in their minds. They're doing it so that they're prepared at trial. And let me show you how easily it's going to be for them to bring in the alternative suspect defense by building up that drug case at trial. This is exactly how they're going to do it, folks. And this is why I get a little bit excited to anticipate the trial. How to introduce the alternative suspect defense? Well, the number one way to do it is through witness testimony. Call witnesses who can testify about the alternative suspect's connection to the crime scene, motive, opportunity, or other relevant details. And the second part is during cross-examination of state's witnesses. Utilize cross-examination of the state's witnesses to highlight inconsistencies or gaps in their testimony that could support the alternative suspect theory. So you can see on the left here, look at all of the potential state's witnesses that Ann Taylor could absolutely annihilate on the stand and bring in the alternative suspect theory. Now, we all know from the beginning, when we talk about the mama, the stepmama, the dad, that Ann Taylor, even if she wasn't their direct attorney, she was the head of the public defender's office. So let me tell you, when they made their plea deals, if they were confidential informants, the attorneys will know that, because they have to make the deal with the prosecutor whenever that goes down. That is why I believe that Mr. G and his attorney in the beginning tried to get Ann Taylor removed from this case due to conflict of interest, because he knew that she would have knowledge of the other parents in the case and their potentials to be confidential informants. So by being a state witness, they put them on the stand. Just think what Ann Taylor can do to them if she already has that knowledge, number one. So entering an alternative suspect defense, there's step one. Then what about their other witnesses that they're going to call? We know that Emma Bailey is going to be a witness for the state. She can annihilate her with an alternative suspect defense. What about calling the officers that were involved? We know Gundy, he was one of the first ones on scene. And she knows now that that's Farley's freaking first cousin's husband. And what about, the other guy, that was, what is his name? Oh goodness, the other guy, the Banfield guy, Rosie. I mean, think about what she can do to Rosie on the stand. And then how about Mabbitt? She's going to take the stand. She's a coroner. When she does, she's going to be available for cross-examination. Well, Kathy Mabbitt was Farley's defense attorney that helped him negotiate that Rule 11 plea agreement. Think about what she can do to her. And then what about Payne? Think about what she can do to Payne. The roommates. Oh my goodness. Think about the questioning that she can do to the roommates to bring in the alternative suspect theory. And then you've got people like Rhodes, Farley, Burroughs, and female Farley, that I firmly believe that when Bill Thompson said that he would need time to put together a list of witnesses, these are the people that he was talking about. So he could potentially be calling them as witnesses in the trial. And if not, you can bet Ann Taylor could. And then how freaking crazy would it be if Ann Taylor called John Judge and questioned him about those plea agreements that he agreed to? How about if she put the prosecutor, Bill Thompson, on the stand and grilled him about those plea agreements? What if she put Megan Marshall on the stand and grilled her about that furlough she granted Farley? And what about Mr. Thompson, Kelly Farley's uncle? What if she got some information on him and put him on the stand? But even more crazy, what if she was able to put Skylar Meade on the stand and get information out of him? This trial could be freaking amazing, but I hope it's dismissed before the trial. But yeah, you want to question whether or not they can interject an alternative suspect defense? This is exactly how they're going to do it, where they're going to do it, and it's going to be a barn burner when they do it. I cannot wait if this thing goes to trial. Oh, but we're not done. See, the other way to bring in an alternative suspect defense is through the physical evidence. If available, introduce physical evidence that could link the alternative suspect to the crime, such as fingerprints, DNA, or other trace evidence. Now, what is the one thing looming over this that we've all talked about? The unknown male DNAs in the house. And we got the one on the glove outside that I don't think is relevant, but those two that they found in the house are very relevant, because when you read the court docs, they didn't just find those two unknown male DNAs in the house. They found them in the room with the victims. They found them at the scene. These are unknown male DNAs that were actually near either Ethan, Xana, or Kaylee or Maddie. These are not just random DNA samples from in the house, folks. Read the court docs. But then you've got the Elantra itself. I mean, that could be an easy way to bring in an alternative suspect. And then you've got the physical evidence, such as the blood spatter that we heard from the recent court doc. Blood spatter that could prove that it's not just a knife stabbing somebody, that it's more than one murder weapon, and it was done in a different manner to where more than one perpetrator had to have committed the atrocity. And then they talk about fingerprint analysis. We know it's not Kohberger's. Is it alternative suspects? And then we've got the forensic analysis of, say, the autopsies on the victims. We know that the wounds aren't going to match. And then it said that they have digital trace evidence of alternative suspects. Like they've got phone evidence of some alternative suspects they were looking at. That's another way to bring it in. And then what about all of the things we know that they can bring in from the crime scene, such as the vehicle that left out at 423? How about the dumpster guy that was walking towards the house at 315? How about that other guy, the shady figure that got out of that vehicle that left at 423 and started walking directly towards the King Road house at 349? And then an easy way to bring in Mr. Tyson in there as a witness is to pull up the Linda Lane audio where you hear somebody yelling, "I see you, Farley." There are many ways that this thing is going to go in an alternative suspect defense, and all of the things that we've discovered can be brought into this trial. It's just they have to be done in a certain way. And you can bet she's prepared to do it. Now, this is the only thing that really frustrates me, especially in Idaho, because as a defense attorney, when you put a witness on the stand, you need to ask the right questions. If you ask the wrong questions, then you can actually hurt your defense. And the best way to keep from doing that is to depose the witnesses prior to trial. That way you know what their answers are in advance. But for some reason in Idaho, not all witnesses can be deposed in an Idaho capital murder case. But a party can request that a specific witness be deposed. The court will decide if the deposition is necessary to preserve testimony for trial. So basically, if they want to depose these witnesses to know what they're going to testify to, then they have to file a motion and the judge has to approve it. So we know that isn't going to happen. But when can a witness be deposed? A party can request the deposition for a prospective witness after the complaint, indictment, or information is filed. I haven't seen any motions for deposing witnesses yet. So Idaho Criminal Rule 15 on depositions, and you can see when taken. In general, at any time after the filing of the complaint, indictment, or information, and on notice to all parties, a party may move that a prospective witness be deposed in order to preserve testimony for trial. The court may grant the motion if the testimony of the witness is material and it is necessary to take the deposition of the witness in order to prevent a failure of justice. If the court orders the deposition to be taken, it may also require the deponent to produce at the deposition any designated material that is not privileged, including any book, paper, document, record, recording, or data. So while I would like for Ann Taylor to be able to depose all of those witnesses prior to trial so she would know exactly what to ask them, apparently that's not going to be possible. So when she does ask these questions at trial, she's going to get answers on the fly. So I hope they are prepared for the answers that they may get, because we got a lot of liars that are going to be put on that stand, it looks like. So, can the alternative suspect information be brought up at trial? You betcha. And I just showed you, per the law, how they're going to do it. And, you know, this investigation that I've done into this case, I've said it many times, I believe all I'm doing is mirroring the investigation that the defense investigators are doing themselves. So the only difference between them and myself is they can't say anything, but I can. And I think the more we get this out in the airwaves, the less people are going to be shocked when the trial happens, and the more open-minded they will be when they hear the information for themselves. So, yeah, public perception is absolutely essential when you've got a massive machine of mainstream media and social media all reporting on negative information about Bryan Kohberger in this case, trying to impeach him to be guilty before he ever goes to trial. The more information that we can get out there into the public sphere to try to keep this thing as on an even playing field as possible, well, I mean, I think it's our duty as citizens, so I will not stop. I will not stop. But yeah, you can bet this stuff is going to be brought up at trial. I love it. Please like and subscribe to the channel. Post your comments, thoughts, your criticisms. I'll have the doc video out to you later today, and then tomorrow night I got you a barn burner. Until then, Pavarotti's out.
I was an ordinary boy until I broke the rules.